When was the last time that you evaluated the risk within A, your portfolio, or B, your estate plan, or C, your tax planning? What we're talking about this session is why you need to evaluate your risk. My name's Sean Todd, tax attorney, CPA, certified financial planner, and we take that more holistic approach because we are trained as a tax attorney, so we look at things at a different slant, the worst case scenario. And then being a CPA, we understand the tax rules, regulations, and code sections. And then being a certified financial planner, being an RIA, we have a fiduciary duty to act in our client's best interest. So this is a unique combination, not very prevalent within the industry of CPAs, tax attorneys, or financial advisors, or stockbrokers. Stockbrokers are not licensed to give tax advice, and any of your financial decisions always involve a tax consequence. So let's evaluate your risk a little bit more on the estate side. We touched on it right before in last session on how you can disinherit your kids a blink of an eye on the largest financial asset. If you didn't get to that session, definitely listen to session number 3. Very important. So let's think about this. What is your risk? Your risk within your estate plan is that you can easily disinherit your kids. You say, wait a minute. My last will and testament says I give everything to my wife or my spouse, whichever one wants to pass away first. And it's called an I love you will. I give everything to my surviving spouse. And if there is no surviving spouse, I give it to my kids in equal shares. Pretty simple, pretty straightforward. But let's evaluate it one step further. We know that we are all living longer, and I, in my practice, have seen multiple times individual passes away, and it may be in their 60s. Well, you know what? 60 to 80 is a long time. That's 2 decades. So the individual meets someone else, becomes involved with them, and then gets remarried. Okay. So he has kids on his side. She has kids on her side from previous marriages, and they want to do some estate planning. Well, they give each other some, or they go down and they do it the cheap, easy way. They get on the internet and drop a document in from, the internet, and they sign it. And guess what? It becomes an I love you will. They don't really understand the implications of that. So when that new marriage comes in and it's H2 and W2 for the second marriages, well, an I love you will says everything to the surviving spouse. Well, what happened to the kids on that first marriage? Well, they're disinherited because now whoever survives that second marriage gets all the kit and caboodle. They get the entire estate, and the kids are knocking on the attorney's door saying, wait a minute, what's going on? The attorney says, I didn't draft this document. It looks like it was pulled down from the internet and signed off. And guess what, kids? You're stuck. You are not getting anything of your parents that passed away. And they look at you and say, well, I'm going to contest it. Well, good luck contesting it. It's not going to be held up. The courts, the black robe, is going to go with the document and say, tough love. It's all going to that new spouse. And the kids are going to look in and say, that's not fair. Well, the justice system is not that. It's not a justice system. I've been through it. It's not justice. The intention of the decedent is upheld by the court as much as they do. And they don't want conflict. They say, hey, look, these two individuals both had mental capacity. They pulled it down from the internet, or, they don't know where the document came from. But lo and behold, they have signed off. It's notarized, and it has the 2 witnesses. It is a valid will. So therefore, we're going to uphold that for the plan of distribution of the estate of the decedent. And the kids will be disinherited. So this is a wake-up call to give our office a call at 404-250-9798. That number again, 404-250-9798, to get your estate plan in force and effect to not have this risk of potentially disinheriting your kids. So how do we do this? Well, we say, okay, first spouse passes away. We are going to create a trust that is going to be held for the benefit of the surviving spouse. But if the surviving spouse gets remarried, they cannot leave these assets to that new spouse. It's simple. It is a tool. It is a very effective tool to eliminate the risk that you are going to disinherit your kids. It's the only way you can do it, because if you do this I love you will, everything goes to surviving spouse, there is no restriction on that surviving spouse. They can leave it to the new spouse. So in order to protect that, we say when the first spouse passes, place it in trust for the benefit of the surviving spouse. When the surviving spouse gets remarried, no change. Doesn't happen. They can't change it. They can't make or modify that trust to give it to their new spouse. That's a pretty huge point. Now, what happens when that surviving spouse passes away? Well, doesn't matter that they have an I love you will saying I give everything to my new spouse. Doesn't control the trust assets. The trust document itself controls those trust assets. And those, based on the first marriage agreement between the parties, is going to go to the kids of the first marriage in equal shares. It's straightforward. But you, as a listener here on the Professional Edge, you have to put this in place before something happens. And let's not wait until you get the bad afternoon at the doctor's office and they say you need to go to the hospital, you need a procedure, and then you're there on your deathbed and, I need to get my estate plan in force and effect. And yes, as a practicing lawyer, I have been to hospitals signing estate planning documents, and that is not a fun afternoon. That is a very, I can't, you see how tongue-tied I am. It's very disturbing knowing everything we know and the availability of information and the availability, just like you as a listener here on the Professional Edge, of this knowledge to put this in force and effect now, before you need it, before that last hour to try and do something on the hurry to get it in force and in place. So, wake up call. If you have that I love you will, that is not a guarantee that your kids are going to inherit your estate. It's not. So, what you do is pick up the telephone, 404-250-9798. That number again, 404-250-9798. Schedule a consultation and walk through the assets in which you have. Being a tax attorney, a CPA, certified financial planner, we examine how this is going to go. We integrate our planning. And that is your financial assets. Certain ones are controlled by beneficiary designations. Yes, you can actually have a beneficiary designation on a brokerage account. That designation is going to supersede whatever you have inside your estate planning documents unless we address and have it go directly into that trust. So we meld these together. Being that tax attorney and the registered investment advisor, we understand these core disciplines, and it is a unmatched combination within the industry. Ask your stockbroker, are you licensed to give me stock advice? Or yes. And then you say, well, are you licensed to give me tax advice? And watch them hem-haw around. They're not. They are not licensed to give tax advice. So look at the bottom sentence of your statement. We are not licensed to give tax advice. Consult your tax counsel on that. Well, if I'm making financial decisions, I want to be able to have tax advice. But also, the bigger play is I need estate planning advice to make sure I don't have that risk of disinheriting my kids. That's important. So we meld this together, being all three disciplines, and we say, okay, when you pass away, where is these accounts going to go and how do you want them controlled? Do you really want your spouse, which they all sit at the table and say, well, if something happens to Barry over here, I'm never going to get remarried. Barry says, well, if something happens to Martha, I'm just going to be off on my own and I'm going to go fishing a lot. Well, that's all well and good, but that's no guarantee, because people are people and they meet other people, and lo and behold, the relationship develops, and then next thing you know, they're getting married, and now we have this blended family, and there's no guarantee that your kids of the first marriage is going to receive anything. So if you want to leave the chance, just switch the station, get a different podcast, listen to something different. But if you're serious about evaluating your risk of disinheriting your kids, either A, on your IRA account, your 401k, again, if you've named your spouse, and 98% of our listeners have named their spouse to be the primary beneficiary on their IRA. Default. Stockbroker doesn't know any different. Well, being trained as a tax attorney, understanding estates, I am understanding of what you need to do, and what you need to do to guarantee your kids don't get disinherited is to draft a trust and have that trust being the beneficiary on that IRA. That way you can guarantee your spouse can use it, access it, that's great. But if she meets Mr. Romeo on H2, she can't change the beneficiary designation to allow Mr. Romeo to receive the IRA that you worked your 30 years for to accumulate money to sacrifice for your family. You can guarantee that your family receives those funds when your surviving spouse is done with it. That's the only way you can do it. There is no designation in Fidelity, Charles Schwab, Morgan Stanley that makes that happen. That's why you have to integrate that with your estate planning. Being a tax attorney and a registered investment advisor, we meld these two together, these two disciplines. It's unmatched in the industry. So give our office a call at 404-250-9798. That number again, 404-250-9798. So we've evaluated multiple risks within your portfolio, your estate plan, and your tax plan. With all these risks, need to take action. Give our office a call at 404-250-9798. My name's Sean Todd, tax attorney, host here on the Professional Edge. Hope you gain some valuable insight on the risks in which we all need to address.
With today's financial markets, are you getting the personal and professional attention you and your money deserve? Clients of estate management counselors benefit from having one set of professionals advise them on their tax, estate planning, and investment advice. We call that the Professional Edge. Sean Todd is a tax attorney, CPA, and certified financial planner. With over 15 years' experience, he welcomes the opportunity to assist you in preparing for retirement, implement effective tax planning strategies, and to help you properly plan your estate. His radio show, The Professional Edge, is aired weekly on Sundays at 9 a.m. If you're interested in meeting with Sean, call his office at 877-654-9798. That's 877-654-9798. Do you want to feel more confident about making the right investment, tax, and estate planning decisions? Today, these decisions are more complex than ever. Have you thought about working with a professional advisor and not sure who to turn to? Not sure what qualifies one to be an advisor? Sean Todd is more than qualified as a tax attorney, CPA, and certified financial planner. Sean is with Estate Management Counselors. Estate Management Counselors operates as an independent fee-only investment advisory firm. They're dedicated to gaining a personal understanding of their clients' objectives and implementing professional counsel and advice to achieve those objectives. So take a second to talk with Sean Todd to learn how you can benefit from their multidisciplinary practice where they coordinate their clients' legal, tax, and investment strategies into one comprehensive and integrated plan to enhance and protect their clients' financial security. You can reach Estate Management Counselors and speak with Sean Todd by calling 1-877-654-9798. That's 1-877-654-9798.